Good morning and welcome to the Court of Appeals. We have two cases on our 9 o'clock docket. We will then take a short recess to reconfigure the court before hearing our 10 o'clock case. I see we have experienced counsel and they're set up. On our first case, does either of you have any questions? For purposes of our spectators, if any of you has a cell phone or similar device, would you please turn it off so that the lawyers are not interrupted? Otherwise, we're ready for argument in People versus Chavez, and we would remind counsel that the division sent out an order concerning a specific question that we want counsel to address.
Thank you, Your Honors. May it please the Court, my name is Lynn Hartfield and I represent the appellant Angelica Chavez. The clock is not running, there we go. There is perhaps no more tragic case than one in which an infant dies at the hands of people who are supposed to protect him. But when courts mete out justice, it has to be to those who actually caused the harm and not to those who did not. There's no dispute in this case that it was the baby's father and or grandmother who beat him, burned him, and broke his ribs. That led to pneumonia, that led to sepsis, and that led to his tragic demise. When the state made the decision to charge my client, Angelica Chavez, who undisputedly did not do these things, they had to prove two things. First, they had to prove that she was criminally negligent in failing to notice the severity of his condition in a relatively short window of time. Second, they had to prove that that criminal negligence resulted in his death. Now, what that means is that, but for her failure to seek help, the result would have been different. Now, I want to clarify that I'm not challenging the sufficiency of the evidence on the criminal negligence prong. The evidence was undoubtedly very thin, but under the sufficiency standard on appeal, a jury could possibly have found that due to her inconsistent statements, even though they were obtained during a time when she was up all night and in shock over her baby's death, they could theoretically have found that that was enough. Not so with the causation prong. And the court asked the parties to focus on what evidence supports the jury's verdict. The state's answer brief is telling. They devote less than a page to going through the evidence. And what stands out is that their own expert could only place the time at which sepsis set in as within hours to a day. What stands out is that their own expert could only place the time at which sepsis set in as within hours to a day. Now, she wasn't with her child for a day. She was with him for approximately 6 hours. And we cannot assume, with no testimony in the record, that had she called the minute she set foot in the house, that the result would have been different.
Is this like a med-mal case in which that has to be the subject of expert testimony as opposed to reasonable inferences that a juror could draw without a specific expert opinion?
Well, Your Honor, I think the Dunaway case seems to say that we need an expert opinion. But in this case, there wasn't any evidence. And under Perez, evidence is not sufficient unless there is some evidence that would support the verdict. And here there wasn't any. It would be mere speculation to say that if sepsis sets in some window of time that's hours to a day, that it set in within the 6-hour window. There was no evidence on that point. And so that's what makes this an insufficiency case. And this is just like Dunaway. In Dunaway, there was no evidence to suggest that had the defendant called for medical help earlier than he did, that there would have been any difference. And it's the same here. Now, this was an issue that all the parties were aware of throughout the case. And we look at day 2 of the trial. A juror asked if the child could have been saved if he had received care at 5 o'clock. And the court said, right, I think that's the big question. Because if by the time your client got there it was too late, then I think it's not guilty. The expert, Dr. Wilkerson, gave an equivocal answer to that question. He said, it's possible, it's hard to say with certainty, but if they'd gotten him full of fluids and antibiotics, it's possible. That answer, however, was stricken regarding 9 p.m., The expert said probably not. That answer was also stricken. He also said that probably sepsis would have just been beginning at 5 p.m., but by 9 p.m. it probably would have been full-blown and likely irreversible.
Is a possibility even sufficient? I mean, suppose for a moment that it hadn't been stricken. Is that even sufficient to say that it's possible?
I think that would take it into the realm of speculation under Perez. When we have a situation where we're not getting any evidence that's besides that, then that would be speculation. However, in this case, of course, all that was stricken, so we don't have anything. Finally, the expert said there's really no way of medically knowing that. That answer was also stricken. Now, day 3, the state realizes, uh-oh, we forgot to put in this evidence. So they go and they talk to their next expert who's scheduled to testify, and they get him to give an opinion that maybe it could have been saved within an hour. However, the defense understandably objected to that because there was no notice of this testimony on such a critical issue. So the evidence was never elicited, and the court decided to strike the previous testimony. The court commented at that time, this should have been addressed earlier. And the court also said, I've always had a real question as to whether or not the injuries were survivable at that point, because that's one of the things that essentially has to be proven by the people, that it was her failure to act that caused him to die. The court recognized that's absolutely one of the elements. Now, when Ms. Chavez moved for judgment of acquittal, the court again comments, honestly, what I don't have, that I've never had that's concerning, and that door just got open with Dr. Wilkerson, is whether her failure to act actually resulted in the death of the child. Now, inexplicably, the court concludes, well, certainly a jury looking at it, a reasonable jury, could absolutely have come to that conclusion, even if it ultimately would not be supported by medical opinion. Now, that is absolutely wrong. It's wrong under Dunaway, and it's wrong under People v. Perez, because in reviewing sufficiency, a verdict cannot be supported by, and I'm quoting from Perez, guessing, speculation, conjecture, or a mere modicum of relevant evidence.
Does Perez, Dunaway, or both expressly hold that there must be an expert opinion on the causation?
Dunaway certainly suggests that by reversing based on the lack of expert evidence. That wasn't the question at issue, but Dunaway did reverse based on the lack of any evidence showing that there would have been some difference if the defendant had called for help sooner than he did. Now, that's exactly what we have here. Essentially, their best testimony is Dr. Wilson saying sepsis sets in within hours to a day. That's their best evidence. And I want to use an analogy here. Let's suppose that the prosecution had to prove as an element of some offense that I was in this building between 8:30 a.m. and 11 a.m. And let's also suppose that they go and they talk to the security people downstairs. And the security people downstairs say, we keep track of when people come into the building, but we don't keep track of the time. So I can tell you she was in the building sometime between 8 a.m. and 6 p.m. That's not sufficient to prove that I was here between 8:30 and 11. It would be speculation, if that's the only evidence that you have, to say that I was here during that window of time.
Didn't Wilkerson also say that in an infant, although sepsis is usually fatal, not always?
What Dr. Wilkerson said is that it is almost always fatal. That's what he said. He didn't say with respect to infants. He said sepsis is almost uniformly fatal. And then he speculated that possibly if you get somebody full of antibiotics and fluids, they might survive. But he did not set a time frame for that.
That testimony
he
wasn't
didn't set
stricken,
a time frame.
correct?
That was not stricken, but he didn't say that relative to a time frame. What was stricken was the part about the time frame.
Well, is it necessary to have time frame testimony?
In a case like this, yes, it was, because there was no other evidence during that window of time when she was there. There was no evidence. So if we know that sepsis sets in At some point within hours to a day, we have to have some other evidence that places it within the window that she was there.
Well, I mean, that's only half the equation, though. I mean, he also said that it's not always fatal, and here's a line of treatment that can save the person.
Yes, he did, but he did not say at what point it could save a person. There was also significant evidence that the baby was in very bad condition several days earlier. There was evidence that all of the injuries that he had, the broken ribs, were old. There was evidence that he was dehydrated, which the doctor opined would take 48 to 72 hours to get to that point. There was a significant amount of evidence that this child was unfortunately beyond saving by the time she walked in. But there was no evidence to counteract that he could have been saved. I want to move on to the second issue, if the court has no further questions on the first issue. The court erroneously barred Ms. Chavez from introducing a statement that would have established that the baby had been exhibiting signs of pneumonia several days before she arrived. And again, that goes to the causation element. This is important because the longer he had been visibly ill, the weaker the state's case became on the issue of failure to seek care. Now, under Nichols, the statement by the father was a statement against interest because it did, in fact, subject him to criminal liability. Now, the fact that it's unlikely that a person would make this statement unless he believed it to be true is the rationale for the exception. It's not a requirement for letting it in under Nichols. However, the court erred by looking at his subjective belief about the possibility of criminal liability. That's not the linchpin. The linchpin is, did this statement expose him to criminal liability? And the answer is yes, it did.
I'm sorry. Didn't he also say that this child had always exhibited breathing problems since the time he was born? And I think if you look at that, because that was in the same statement, that seems to me to be much more exculpatory than inculpatory, like he's giving a reason for this child's condition.
Well, when we have a statement that's both exculpatory and inculpatory, we have to take the statement apart and see whether it would be admissible, either part of it or all of it. However, when you look at the context of the question, he's being asked this at the hospital, and he says he said specifically that the baby was having trouble breathing a few days before. And then he later says, well, he's always sort of had trouble breathing. However, there was testimony that Ms. Chavez had brought the baby in to see the doctor a few months before that and complained about him having trouble breathing and that he had been checked out and there were no problems. But given the context in which this statement was made, particularly given the fact that the father exhibited signs of consciousness of guilt because he did not want to call 911 and he did not want Ms. Chavez to use his telephone to call 911. I think we can certainly conclude that this statement was a statement against interest, and it was error for the court not to let that in.
Because the jury heard that grandmother admitted that the child had been experiencing a fever in the days prior, doesn't that minimize any harm in excluding that statement? I mean, clearly the jury knew that while this child was in the care of grandmother and father, the child had a fever, and ultimately it was this fever that was a signal of the pneumonia that then resulted in the sepsis and everything.
Well, this was a more specific timeline, what the father said. And that is, of course, the timeline is critical in this case because they had to prove that Ms. Chavez's failure to call for help broke the chain of causation. And when we have specific testimony from the father saying, yeah, he was having trouble breathing a few days ago, that is critical evidence to establishing a timeline as to how sick he was at the time that she walked in. So if the court has no further questions, we'll stand on the briefs on the remaining two issues and reserve the remainder for rebuttal.
May it please the court, counsel for the appellant. My name is Jennifer Carty, registration 48991, and I represent the people on this matter. And I'm going to address the court's question of, but for the defendant's failure to seek medical treatment for the child, would the child have survived? As this court knows, we don't sit here as the 13th juror. We don't reweigh the evidence. We look at the evidence and discern if we take this evidence in the light most favorable to the people, was it sufficient to support their conclusion? And it's our position that it was. I first want to talk specifically about what testimony was struck. I disagree with my colleague as to what exactly was struck from the record. A single line of opinion testimony was the only thing that was struck from the record. Specifically, quote, that the baby could have survived if there was medical intervention at 5 o'clock and or 9 o'clock. That is the specific line of testimony that the court struck. And then it specifically told the jury that it could consider all other testimony from the doctor. So what was available to the jury? The doctor testified the baby had bacterial pneumonia that progressed into the bloodstream, causing sepsis. He testified that sepsis is rapidly fatal unless the person suffering from sepsis is taken to the hospital and treated with antibiotics. He also testified that kids specifically get well fast if they are caught in time. And I also have record cites if the court would like those. Those two pieces of testimony indicated that sepsis, when treated in the early stage, is survivable. Now, the doctor also offered an opinion that he believed the sepsis set in around 5 o'clock p.m. Mother arrived shortly home after that. Sometime around 5:30 is what the testimony tells us. So this is the very beginning stage of sepsis, the beginning stage of sepsis that is treatable, the beginning stage of sepsis that a child can recover from quickly if it is caught in time. This baby is not in the end stage of sepsis, which involves hypothermia and loss of consciousness, until 7 hours after mother is home. So what do we have? Sepsis is treatable if it's caught early, if a person's taken to the hospital and given antibiotics. Kids specifically get well fast if sepsis is caught in the beginning stages. The baby was likely beginning to get septic right around the time the defendant arrives home, and his condition would have been obvious. It would have been obvious that this child needed medical attention. And it was a reasonable inference based on that evidence for the jury to draw the conclusion that the baby was still treatable when the defendant arrived home, and that her failure to take that child to the hospital contributed to his death.
Well, let me return to a question I put to your adversary. Is this, I mean, everything you said sort of makes sense, but there still is a lack of a medical opinion that, but for a certain passage of time, the child would have survived. Okay, right?
Yes, Your Honor.
All right. And I suggested the analogy to medical malpractice cases. I mean, unless the nature of the malpractice is so obvious that reasonable people couldn't disagree with it, like cutting off the wrong leg, the cases require an opinion that there was a failure to meet the standard of care here, an expert opinion. Why isn't the same thing true here? I mean, why is it a matter of inference rather than requiring the state to call an expert to say, but for the delay of 2, 4, 5 hours, the child would have survived?
I don't think that Dunaway stands for the proposition that you have to have expert testimony. I don't think it's the same as it is for med-mal, because when we look at our standards, even if there's different inferences that can be drawn, if we had, say, 2 experts that show up, one says, yes, it was survivable at 5 o'clock, one says, no, it wasn't survivable at 5 o'clock, the jury is still allowed to draw its own inferences based on the evidence. And even when different inferences can be drawn, the evidence is sufficient to support the jury's conclusion. There's enough here if we take this in the light most favorable to the prosecution, that I think the jury is allowed to come to that conclusion. They don't need medical certainty, because medical certainty is kind of not even a real thing, right? You talk to 5 doctors, you'll get 5 different answers. And this is an infection. Infections don't progress upon a distinct timeline where we know every second what's going to happen in this particular child with this particular infection. But that doesn't mean that we don't hold people responsible for their conduct. So I think that knowing that the infection was treatable in the beginning stages, knowing that this child very obviously needed medical attention, and that the defendant chose not to get medical treatment for this child and instead allowed that infection to progress. I think that evidence is sufficient enough that the jury should be allowed to draw its conclusion that this woman contributed to the child's death.
Suppose Dr. Wilkinson had been asked the ultimate question and said, I don't know whether the delay of 2, 4, or 5 hours would have made a difference in the outcome.
I think that would have hurt the case, but the doctor said probably.
Well, but would that be fatal? Would that be, poor choice of words on my part, I apologize. Would that have required a directed verdict for insufficient evidence?
I think
and if not, why not?
I think it would involve, I think these types of cases are very fact-driven. I think the jury is allowed to rely on all the other evidence too, and to rely on their own common sense. For example, bacterial pneumonia. We don't know what the timeline of bacterial pneumonia is as a layperson, but we know it's treatable because we've experienced relatives who have pneumonia. And the pneumonia was what caused this child's death. It got into the bloodstream and created sepsis. So I don't think just because we don't have an exact timeline doesn't mean the jury can't use what it knows, that sepsis is treatable if it's caught early, that it should have been caught early in this case, and that kids get better fast. I think that's enough to support the jury's conclusion in this case, and that they can use their own evaluative skills and what they know about illness and progressions of illness to conclude that she contributed to the child's death.
Counsel, how do you reconcile that with the fact that the medical professionals, when the child got to the hospital, didn't treat it as an infection, didn't treat the pneumonia, they didn't give the child antibiotics right away?
At that stage, they're performing life-saving measures, and as the doctor testified, at this point, he's just trying to get critical breathing back, heart rate, so that he can start diagnosis. Because by the time the child is brought in, we're 7 hours into this infection, and this child is unconscious, the child's lost its heartbeat. They don't know what's wrong because at the moment, they're just trying to get the child's heart to beat again. So I don't think that the doctor's testimony as to what life-saving measures were done 7 hours into the infection are necessarily determinative, that the jury couldn't have drawn the conclusion that had the defendant taken the child for treatment, he could have survived.
So you said that Dr. Wilkerson said probably, but I thought what he said was it was possible. And if that's so, is there a difference between probable and possible, and where do you draw the line from a certainty standpoint?
To be honest, Sharon, I don't recall specifically if your word is the word or my word, but I think relatively they are kind of the same concept. He's not speaking with medical certainty because he doesn't know. Infections don't progress upon a very specific timeline every time the same way, which is why he testifies that infection can progress in a matter of hours to a day. It depends on the individual and it depends on the complications. But I don't think that prohibits the jury from ever concluding that this was a source that contributed to the child's death. And had that child been treated and the possibility existed that, you know, had she taken the time to take him for medical treatment, the jury can conclude that she contributed.
Your counterpart's not even contesting the criminal negligence, as I understand it. So really, we're just talking about causation. That's why I'm trying to pinpoint what constitutes but for in this context. What is the certainty that we're looking for?
I think the evidence just has to support the inference the jury made. The jury doesn't have to know within, you know, a certain degree of medical certainty. The evidence just has to support what they decided, and I think it does. Here, they had enough information to know this kid was obviously ill. She should have known this kid was obviously ill. Had she taken him to the doctor right away, he was treatable, he was a kid. They heard enough to know that kids get better fast and are probably more easily treated in the beginning stages, and that was enough for them to conclude that she contributed to his death.
Now, in the dialogue between you and Judge Rahman, he uses the phrase "but for." You use the phrase "contributed to." Is there a difference, and if so, which does the statute of the cases tell us we should apply?
I'm sorry, could you repeat the last portion of your question?
Yeah, well, as between those two phrases, which is more supportable under the cases or the statute, contributed to or but for? Because that seems to me to be different, but I'm not sure it is.
In this case, I'm not sure that it's a major difference, just because either she was going to get him in time for treatment or she wasn't. So in a sense, there were multiple causes of death in this case. We have the initial physical injuries and the subsequent complicating infections, which exacerbated and ultimately resulted in the death.
Okay, but the delay in seeking medical treatment, it seems to me, would be more likely a jury question if the criteria was contributed to than it would be if the criterion was but for this lapse of time, the child would have survived.
Well, so I don't have a specific case to cite to you for the way I'm looking at this. I know the sentence's answer is ultimately resulted in death.
Well, that sounds like but for to me, not contributed to.
But her failure to act was not the sole cause of death, and that's why
Okay.
I'm
All
using
right,
the
okay.
contributed
Okay,
to.
fair enough, thank you.
As for Dunaway, I don't believe that Dunaway stands for the proposition that expert testimony is necessary. I think it stands for the proposition that there has to be some evidence that the delay in seeking medical treatment exacerbated already existing injuries. I think we have that in this case, as I've already discussed. It's undisputed that the victim died of subsequent infections that progressed over a period of time. And the failure to get medical treatment allowed those infections to progress, thereby exacerbating the physical injuries. The prosecution must be, Your Honor, did you have a question?
Sorry, yeah, no, but aren't there several delays here? I mean, there was a delay in getting medical treatment on behalf of the father and the grandmother when the child had this fever that then led to the treatment. There was the delay in mom taking or calling 911. So how do you distinguish which delay is what ultimately caused the child's death? Because Dr. Wilkerson said hours to a day. Doesn't that cover both?
But he also said he believed that the sepsis, which is specifically the infection that resulted in death ultimately, caused by the previous infection of pneumonia. So yes, there is an initial delay. But the sepsis becomes fatal, and the sepsis sets in right around the time that mother arrives home and the child is in her care. And the sepsis is what ultimately causes him to pass away in combination with dehydration, which is why, as I was talking about with Judge Webb, it's a contributing cause of death, not the sole cause. But there is evidence that that specific delay, the delay in the treatment of the sepsis, ultimately resulted in his death.
But his testimony was hours or day, and she got treatment within hours. So how can you say that?
He said it progresses within hours to a day, and then he believed it set in at 5. He also testified that hypothermia is the end stage, and this child was cold to the touch 7 hours later, and that's when he lost consciousness. And if your honors have no further questions, I can address the other issue that my colleague addressed if you would like me to respond to that as well. I have a minute left, so I'll just use that time for that. The people agree that the proper admission test for father statements against interests involves the unavailability of the witness, that the statements tend to subject the declarant to criminal liability, and that corroborating circumstances must demonstrate trustworthiness. What we disagree with is that the trial court applied the incorrect standard. The trial court's statements, although inartfully expressed, were not incorrect, and they related to the second prong of the test. The trial court's ruling amounted to a conclusion that father's statements were unreliable. Why? Because the statements did not tend to subject the father to such a degree of criminal liability that a reasonable person in his position would have believed that they were true. Put another way, the more glaringly a statement subjects someone to criminal liability, the more likely it is that they believe that what they're saying is true. Why? Well, we generally don't go around making up statements that incriminate us and could subject us to criminal charges. So the trial court was attempting to say that these statements did not tend to implicate criminal liability to such a degree that a person in the declarant situation would have known or believed that these statements were true. And if we look at the case law, we see that is the case.
Your time is exhausted, so if you could wrap up in a sentence.
Sure. The decision of the trial court was not an abuse of discretion. The statements did not clearly subject the defendant to criminal liability, and the statements also lacked trustworthiness for some of the reasons previously discussed with counsel. Thank you, Your Honors.
Thanks.
Thank you. I just have a minute here, and I just want to point it out. I think counsel is overstating the record, the evidence on what sepsis is and how often it is treatable. This is March 7th, 2017 transcript at page 228. Dr. Wilkerson is being questioned about sepsis, and the question is, it pretty much gets infection throughout your entire body because it's going through your bloodstream. That's correct. So it's an overall infection. It's very dangerous. Yes, it's almost uniformly fatal. It's very rare that people survive it. If you can catch it and get someone onto a very serious course of antibiotics and other treatment, you can sometimes treat it, but it's not something that many people recover from. Correct. That is not enough to state that had this baby gotten treatment for sepsis 6 hours before he did, he would have survived. In fact, it's really much more the opposite, which is once sepsis sets in, most people don't survive it. And I just wanted to make that point. Second point I'd want to make is
Let me
about...
stop you there, because your opponent ran over a little bit. You can do likewise. So would it have been sufficient if the doctor had opined that this baby was treatable, without regard to the time element?
Not without anything else, no.
So you're saying that you need an expert opinion that not only was on the particular facts here, not only was the sepsis treatable, but it was treatable within this 6-hour window.
Yes, and the case that I would cite to is People versus Calvarisi, and that talks about when you have two different causes.
Is that in the briefs?
No, it's not. I just found this case. 534 Pacific 2nd 316. And what this talks about is when you've got an intervening cause. So this is a case in which the original actor causes some injury and then tries to defend the case by saying somebody else is an intervening cause that I couldn't foresee. In that case, gross negligence will break the chain of causation. So that's what we have here. This is what the prosecution alleged, that Ms. Chavez's failure broke the chain of causation, and we don't have enough evidence on that point.
Thank you.
For these reasons, I'd ask the court to reverse Ms. Chavez's convictions. Thank you, Your Honors.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. As soon as the tables are cleared, counsel in our second case can set up. next case on the docket is Oddfellows Building and Investment Company versus Lee and Barbara DeMary. Gentlemen, ready to proceed.
Yes, sir.
Good morning, Your Honors. My name is Steve Shiagi. I am counsel for the appellant. The appellant is Oddfellows Building and Investment Company of Englewood, Colorado. We are here on a case that is quite different than the arguments you've heard just a moment ago. We are here on a dissenter's rights case. This case, just briefly, came about when there was a sale of a building on South Broadway. There was a dispute over whether a notice properly went out to one of the minority shareholders, Mr. DeMary. Under the dissenter's rights case statute, Mr. DeMary asserted his rights, and my client ended up, under the statute, becoming the plaintiff in the case. So this is procedurally how we ended up here today. The short of it is, there was a sale of this building that took place on December, I believe, 8th of 2014. The sale was for $450,000. When Mr. DeMary asserted his rights, we proceeded with the case. There was a bench trial that took place at the summer of 2017, and the trial judge gave a value to the building, which is part of the appeal today. And so there are three issues that I wish to cover with Your Honors this morning. The first would be the determination of fair value, and specifically the use of rejected hearsay testimony that was not admitted into the record as part of that determination. The second is the trial court's determination not to deduct expenses associated with the sale of the building in determining fair value. And if we have time for it, I'd like to address the cross-appeal by Mr. DeMary of the directed verdict that he believes should have been issued. So those are the three issues I'd like to address. So first of all, let's go to the fair value valuation. In the case, there was testimony from a court-appointed expert in accordance with the statute. His name was Mr. Nesner. Mr. Nesner put a fair value of the building at $475,000. Mr. DeMary had his own expert witness who put a number on the building that was quite a bit higher. My client, Oddfellows, did not have its own independent expert. So we've got the two experts. And as you read from the trial court's opinion, there was some very strong praise of the analysis and the approach and the detail used by the court-appointed expert, Mr. Nesner. The trial court declined to use the valuation put on the building by Mr. Hart, who was Mr. DeMary's expert witness. And in the end, the problem that we face is that the trial court decided that the fair value of the building, as you saw, was an average of two numbers. The court-appointed expert's number of 475 and the number put on the building by this unadmitted document, this equireal appraisal, which was Exhibit Q. And
Counsel, I understand that that was not admitted based on hearsay, but Mr. DeMary testified, and you didn't object to admission of Defendant's Exhibit Z, which included the equireal appraisal. So why isn't that properly in the record for the court to consider?
The Exhibit Z was a summary, and as you saw, was a timeline of events, Your Honor.
But you didn't object to it.
That is true. We did some voir dire, but it doesn't make the, as I understood it, the summary does not make the number from the equireal document. It's not for the number that was asserted. It was admitted simply for that timeline that he put into the testimony.
Well, page 1 of it looks to me like it is a comparison of all the different appraisals that were presented during the bench trial.
Right.
And it doesn't say that it's necessarily a timeline. I don't see on page 1 any timeline information. It's just, these are all the numbers that are out there. And I think under the Pueblo Bank Corp case, the judge isn't bound by any particular mathematical formula in arriving at fair value. So I guess I'm failing to see how this equireal appraisal isn't properly a consideration for the court, given the fact that it's in an admitted exhibit.
I would still argue, Your Honor, that the number in that document, it wasn't admitted for the truth of the matter in terms of the number. We are still faced with the problem that the equireal appraisal itself was not admitted. There was no testimony by any person of how that number was arrived at. There was no testimony by any person, of course, because there couldn't be, that what the valuation methodology was used, whether it's supportable or not. All we have is the number. And obviously we have that situation where that what I would call the timeline, you're calling it the summary, came in, and that is obviously that's the situation we find ourselves in today.
Right, and another question, Mr. Hart testified to it. Ultimately, the court decided that Mr. Nesner's testimony was more credible, but that doesn't mean that she completely disregarded everything that Mr. Hart had to say. She just said that she accepted Mr. Nesner's methods of computing fair value as being the more credible way to consider fair value.
And Mr. Hart testified that he used the comparable sales. He adopted those comparable sales from the equireal report, and he used them in his own. He didn't testify as to how that number in the equireal report, for example, was different than his, or the differences of how the procedurally and in terms of what approaches they used were different than his, and how that would be. So all we have is the situation where it came in through Exhibit Z, that number, and there's still no testimony deciding how it got there in the first place.
Well, we know that it was the bank's appraisal, right, as part of the sale.
And the problem, well, and the evidence in the case was, this came from Mr. Greenberg, who was the buyer. The bank did that appraisal because it didn't look at each property essentially separately. It was looking at it as a bundled deal. Now, of course, they came to this separate number, but there is no testimony that I can recall or that I saw in preparing for today that explained how there was a number for one building and another for a number for the next door building. And this is the major problem with the equireal report, and this is frankly why it was not admitted into testimony.
Doesn't that go to weight rather than admissibility? In other words, we might come up with a lot of reasons why the trial court shouldn't have given those equal weight, but that's not what we do.
I understand that question, Your Honor. So here's the problem that I face. As a legal matter, I couldn't find any cases from Colorado that deal with a situation where we have a non-admitted hearsay document that was clearly used to decide a damages number, okay? And so we default, in my position is we default to damages analysis, legal analysis. So we have to have substantial evidence, which is competent, and all those types of description of how a damages standard works, and that's the Palmer v. Diaz case, 214 P. 3rd 546. But to be competent, an analysis or evidence has to be admissible, I would submit. It's an issue of first impression. I will absolutely admit that to Your Honors. But my belief is we're not finding case law in Colorado where either a juror or a trial bench or a trial judge is using unadmitted testimony because it was error on this judge to use the equireal report to do so. And one of the issues that comes up, of course, on appeal constantly is the standard of review for an issue like this. Your Honor, of course, posed the question of whether this is just a weight issue or In my opinion, this is a clear error issue, which I believe is the standard of review for this particular issue. I think it would be fair for this court to set a rule of law, clarify a rule of law, that it is error for a finder of fact, whether it be a bench trial or a jury, to use hearsay testimony or hearsay evidence to determine an issue of fact such as what we have before ourselves today.
Well,
And so
there's other evidence than the appraisal itself. There are references to I think it's to 885 number. Is all that other evidence inadmissible hearsay?
Well, no, because, for example, there is evidence that the two experts who opined in the case looked at it. They looked at the equitable report. They didn't do what they would consider a review, which has its own meaning in the appraisal world. And so they were aware of its existence. But that's our problem, Your Honor. There was no testimony at all in the trial that would substantiate how that number was arrived at in the first place. So while there is other testimony in the record that people were aware that this other appraisal was out there, the trial judge, nor I, nor counsel know how that equitable report was arrived at in the first place, because there's an absence of that type of testimony in the record. Did I answer your question?
Go on.
Go on.
Counsel, you're running out of time. I'm interested in your second issue.
Sure.
Can you discuss the expenses issue that were
Thank
not
you, Your Honor.
deducted?
So on the expenses issue, the judge came to her analysis. She obviously averaged the two numbers, and then we know we have 198 shares in the corporation. Mr. DeMary is a minority shareholder at 35 shares. And so she applied that calculation to the fair value that she determined. The fair value definition in the statute is 7113-1014. And it says, fair value is defined as the value of the shares immediately before the effective date of the corporate action to which the dissenter objects, excluding any appreciation, depreciation, in anticipation of the corporate action, except to the extent that that exclusion would be inequitable. Now, under that definition, there had been costs of the sale already incurred by the company by the time that sale took place. Obviously, they'd hired a real estate agent. They had to do work to clean it up. There was all those types of things associated with the sale of a property that had already taken place. And under this definition, I think it's fairly clear by that meaning that those things should already be included in the fair value because they'd already been incurred, okay?
Counsel, how do you reconcile that with the Supreme Court's language in the Pueblo case that a dissenting shareholder may not be benefited or burdened by the triggering event? Isn't the triggering event the sale?
It is. My understanding, however, that the standard in Pueblo was a fair market value standard, Your Honor, which is different than this one.
Okay.
Now, they talked about fair value in that case, certainly, but there's a distinction between the two.
What do we do with the trial court's discussion of troubling circumstances and how it factored that into its fair value determination?
That's a good question. When you read the order, there is no finding that there was actually any wrongdoing, bad faith, or anything of that kind by Oddfellows whatsoever. When you read the order, Your Honor, it refers to things as interesting, right? She found it interesting that there was an opportunity for valuing this building higher than this building. She found it interesting that, she goes on and on and on. And so I think it's important to recognize that there was no finding by this judge that there was actual bad faith or any wrongdoing at all. Now, she thought about it and clearly gave it some credence, but that's an important point to remember. But second of all, when you read the statute, even if she had found bad faith, I didn't find anywhere in the Centers Right statute or any of the definitions that she could make the leap, even if there was bad faith, to doing things like excluding costs or things like that. I think The trial judge presumed that she could make that kind of a finding, but I don't think the statute allows her to do it.
Okay.
I say I have 26 seconds. If your honors have any questions, I'll try to reserve that time. Thank you.
Good morning, judges. I'm Attorney Robert Abrams, license 37950. And with me is Attorney Neil Sullenberger, who may assist. What occurred was this. The Oddfellows managers, in the majority, owned the Dransfeld building and were the majority shareholders of the Oddfellows building. And they sold this, they bundled these two buildings, of which Oddfellows members had no interest in the Dransfeld building, bundled them together and sold them for $1,250,000, then switched the values of those two buildings and shorted the minority shareholders of the Oddfellows building. That's what happened. And then Mr. DeMary came forward and said, no, you can't switch the values and short us as the minorities, and brought it to dissenters' right action. Then we had a trial, and what happened at the trial was this. Pursuant to the dissenters' rights, we have to determine the value of the shares, not the building, the shares. That never occurred. There was a trial, and it never took business evaluation evidence. It just talked about an asset of the corporation. In response to my counterpart, the court determined the fair value. Now, pursuant to the statute, it is obligated to take appraisers, plural. That would arguably mean any amount of appraisers that could determine the fair value of the shares, And the court only heard real estate appraisers. And because we're the non-moving party, we just simply rebutted with Mr. Hart. So we moved under Rule 50, which is our cross appeal, which I'm intermingling right now, which is important, to simply state, Judge, when you considered Exhibit M to contradict the shares, you erred because that's not what we're here for. We don't have any business valuation, which is the subject matter of the trial.
Counsel, I have a question about that. There was case management order entered in which you stipulated that the only asset of the Oddfellows Corporation was the building itself. How does that not bind you? Why should the court have considered anything else when the party stipulated that there was only one asset, and that was a building?
It wasn't the case management order, it was the trial management order.
Trial management, sorry.
And I agree with you. The reason is, it was more metaphorically, we don't have anything else to sell but the building. But by no means were we conceding in the TMO that there weren't accounts receivable, accounts payable, depreciation, goodwill of a 100-year-old corporation, rental income, and amounts there too, all of which have to be considered in the totality of what's the business valued to determine the cost of the shares. So we don't stipulate that that's the value of the shares. We stipulate that that's the asset to be bought and sold. Now, moving on the exact same point, the court erred in listening. If we go with that premise, there's only one asset, and that's it, and it's the building. Then the court erred at Rule 50 for directed verdict when it took extrinsic evidence, which it absolutely cannot do, to then go in contradiction to the one asset, because it started to take in the CPA's lack of accounting and accountability for the business. That's what Exhibit M was all of the things that aren't in front of the minority to determine if his shares were proper or not. That never occurred. And so if the court listened to that pursuant to the authority cited in our cross appeal, I have it over here, but in the interest of time, I can't pull it, or Neil pull it. The court erred when it considered outside evidence in contradiction to the one asset. Okay. So what ultimately happened was this. Pursuant to the statute, 7113-101, the court heard appraisers, plural, and it came up with a determination. So what we would argue is this. On that determination, since the value of the shares have never been determined, and that's the law, what is the value of the shares? We would argue at the very worst would be a remand down holding the 666 value as determined by the court to hold, to then take new evidence in as to what's the value of the business, not to be reduced by what the court in its own discretion was allowed to determine. I am the judge. I will determine, because you asked me to, what's the value. And I've heard testimony from Nesner and Hart. And on that, I say 666 for whatever, because I have the judicial discretion to do it. She certainly didn't abuse it. But if this court is not satisfied that the law was complied with, that Mr. DeMary and the minority were not paid for the value of their shares, then the only thing that would be proper is, well, let's send it back down and get in business valuators to determine if accounts receivable, accounts payable, goodwill, and other intangibles would affect the 666 number. Okay. Plaintiff presents no legal authority borrowing averaging within the court's discretion. Plaintiff's argument as to reliability of methodology was addressed on cross-examination, and the court weighed that evidence. The trial court is not subject to any precise formula, Pioneer Bank Corp., and supported by Richardson v. Palmer.
Well, I
Yes.
think you may be circumventing or sidestepping a little bit the argument. The argument, as I understand it, is even though there were some references to this 885 appraisal, there's no evidence in the record as to how that was performed, what were the underlying methodology. Is that a correct statement?
885 is determined by who?
Well, I think that's the figure of the bank's appraisal. I mean,
Okay, hold on. Equireal is the appraising body that determined it at $1,250,000 for the bundled sale of equal properties, this is the record, which then determined, okay, we've got two buildings in disheveled condition. They're of like kind. One's twice the size as the other. We don't consider that. The square foot price is about $70 per foot. Multiply it by the size of the two footprints, and that would give you the value of the two buildings equally as by Equireal. And we know that's reliable because the banks just loaned $1,250,000 on that number. Extrapolate that simple square foot price, and they switched the value of the buildings to screw the minority, which is why we brought the suit.
well, is the methodology that you just articulated,
Yes, sir.
$1.2 million for the package, a square foot proration, is that in the record?
Yes, sir. Yes, sir. That is articulated in the record. I don't know how many times, but Equireal is, for the purposes of admissibility into evidence, is arguably hearsay. However, the court heard the testimony and saw it as reduced, as Judge Frere said, in Exhibit M. That's certainly replete throughout the whole testimony. Is Equireal was the basis for Mr. Hart's foundation for his valuation of the building, and discarded by Mr. Nesner for whatever his reasons were. But absolutely, Equireal, although not admitted into evidence, was 100% endlessly considered by the court at the trial level because we saw to it, because it was so relevant that that was the basis of the square footage. The fact that we couldn't get that appraiser who literally wrote it to get on the stand is irrelevant because the trial court considered to reason it all the way through to the very end. And we think that's a primary basis of her carving the building perhaps in half. Should I carry on? Okay,
Please.
great, okay. It was clear to the trial court that Mr. DeMary was underpaid. So the fact of damages versus certain and actual value in controversy, that's irrelevant. And Palmer doesn't stand for that. Palmer is much less relevant than Russell versus First American as to the damages. We know by the very lowest estimate of Mesner that the minority was underpaid. We know this. So for then the court to then say, okay, we have damages, that's absolute. Then the uncertainty